Greetings everyone. Welcome to my YouTube channel. I'm Advocate Puleng. If you are new to this channel, please feel free to subscribe. Also share my videos with your friends, with your family, with your colleagues. Today I will speak on a legal principle. This legal principle is called the presumption of innocence. It is a legal principle to the effect that every person, or should I say every accused person, is presumed innocent until proven guilty. Every person accused of a crime is presumed innocent until proven guilty. Let me start by saying this particular discussion does not necessarily refer to any case that is going on at the moment. It's just a general teaching, because I have seen in the past through the media what is called mob justice, where people will take the law into their hands, or there will be instances where somebody is undergoing a trial. Somebody is being accused of a particular crime, and people start to make a decision already to say, yeah, she is guilty, he is guilty. That should not be the case. The legal principle says every person accused of a crime is presumed innocent until proven guilty. Now, if we say the person is presumed innocent until proven guilty, the question is, who should prove the guilt of this person? It is the prosecution, or it is the prosecutor or prosecutors involved in that case. The law says the burden of proof is on the prosecution, because the law also says he who alleges must prove. It is the state through the prosecutor or through the prosecution that says there is an allegation of a particular crime committed by this person. From the beginning, we call it allegation. That is why we say it is alleged. The person is accused, is not yet a prisoner, is just accused, it's just an accusation for now. It is just an allegation that you have committed murder. It is just an allegation that you have committed arson, or whatever crime that a person will be accused of is an allegation. Therefore, the state or the prosecutor, the prosecution, has a responsibility, has a burden to prove that indeed this person has committed that particular crime. And the prosecution must provide to the court sufficient evidence, compelling, convincing evidence that indeed this person, this accused person who is now in front of the court, has committed the offense referred to. Now, there must be a test. There is actually a test that is used to determine whether this person is guilty as charged. In criminal law, the test that is used, it's beyond reasonable doubt. There must be proof beyond the shadow of any doubt that indeed the person accused of a crime has committed that offense. There must be no doubt. That is why it is said it must be proof beyond reasonable doubt. But in civil matters, the test that is required is on a balance of probabilities. The key word that is probability. There must be a possibility that you have done whatever you are accused of. But in criminal matters, there must be no doubt. Whereas in civil matters, there must be a possibility. That is why it's called on a balance. So in other words, on a balance of probability indicates that the strongest test that is required is that one of, it is in cases of criminal law. Criminal law test is more stringent. Now, as I've indicated, the state must prove. But even the accused must also present their case that says, I am not guilty. That is why there is a principle in Latin, it's called the audi alteram partem rule. Audi alteram partem rule means that you have to hear both sides. You cannot make a decision until such time you have heard both sides of the story. You listen to the prosecution, who would present their compelling, convincing evidence through their witnesses. And when the prosecution is done presenting their case through witnesses, they will close the state case. They will close their case. And then we go to where? We go to the person accused to say, okay, what do you have to say? What is your response? They will respond, and if they have witnesses, they will also present their witnesses to say to the court, I am not guilty. For example, they can say, raise a defense called alibi. What is alibi? Alibi is where you say, I was not even there at that particular day. I was in another city and I have proof. I have people that can witness that on that particular date, I was visiting them or I was seeing a doctor. So indeed, I was not there. Now, Section 35 of the Constitution of South Africa provides for the protection of the rights of accused persons, arrested persons, and detained persons. Now, we're talking about the right of arrested. So, these rights that these people have, the arrested, the detained, and the accused, they kicked in immediately when a person is arrested. This particular person has rights. That is why you will see that when a person is arrested, the police will begin to narrate their rights to them. One of them being telling them what they're accused of, that you have the right to remain silent. And you must know that if you can say anything, it will be used against you in a court of law. So rather remain silent. And also, you have the right to a lawyer. You have the right to legal representation. In South Africa, it's an imperative. It's a must. Legal representation, it's a constitutional right. That is why even if you cannot afford a lawyer in South Africa, you are able to get free legal representation, which will be paid by the state. This is a case now where you have to approach Legal Aid South Africa. You go to their offices, you tell them, I'm accused and I don't have the means to pay for lawyers. They will fill some forms, they will assess the situation. They use what is called means test to establish whether indeed you cannot afford a lawyer. And if you cannot afford a lawyer, the state will then, through Legal Aid South Africa, they will appoint a lawyer that will represent you. Some people are daring enough to say, I do not want a lawyer. I will represent myself. Some people will say, okay, I can afford a lawyer. Therefore, I will engage the services of a lawyer myself. But this is a very important right which is enshrined in the Constitution of South Africa, the right to legal representation. That is why you can even get it at state costs if you cannot afford it. So these rights, you don't have them only at the time of arrest, but even when you are detained. The section talks about the right of arrested and the right of detained. When you are behind cells, you still have rights that you can exercise. That is why even your lawyer can come to you for a consultation whilst you are behind cells. You are still a human being anyway. You still have the right to life. You still have any other rights that other people have that are enshrined in the Constitution. So you do have those rights when you are behind cells. You do have those rights when you are arrested. And you do have those rights when you are detained. Now the question is, because we are saying this principle, this legal principle, is to the effect that you are presumed innocent until proven guilty. I have indicated that the prosecution, the state, because in a criminal matters, it's a matter for the state, the prosecution must prove your guilt. And if you are innocent, you must also provide evidence to the effect that indeed you are innocent. Now, once the matter is presented to the court, who decides whether you are guilty or whether you are innocent? It is the responsibility of the judge. Only the judge. Because the judge has been trained to go through these processes, to listen to the prosecution, to listen to you, to assess and to make a determination as to whether you are guilty or not. It's not the public. Just because they are listening to the case through the media, who, who should decide or who will decide on whether you are guilty or not. It's not up to the public. It's up to the judge who is trained to do the job, who will then decide that indeed this particular person has committed this assault or whatever case it is or whatever crime it is that you are accused of. The responsibility is that of the judge. So it is very important as a society to know that just because a person stand accused of a particular crime, we should not rush and begin to involve in ourselves in mob justice and take the law into our own hands. We should not begin to make weird, wide statements about this particular person and convict them or before even the court makes a pronouncement. We have to wait until such time when the judge says, I find you guilty. It's done that the person will be guilty. It does not matter what theories are being created there through the media or the kind of conclusions that we can come up with as members of society. The person will only be guilty of that particular offense because the court said so. I thank you.